It's probably all my fault. Okay. Good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of November the 15th, 2012. I'm Joey Hargis, and I'll be presenting the cases to the board for review in today's public hearing. I would ask this time anyone, please, if you don't mind, if you'll silence or put on vibrate your cell phone so as not to interrupt today's proceedings. Admittedly, the cell service in this room is not spectacular anyway, so it may not even work, but if you don't mind, we'd appreciate it. The procedure will be to introduce the case record as the Codes Department has it on the wall here and on the television screens at the rear. We'll present any site plans, photographs, maps of the properties involved in today's cases. We'll also present any letters that we've received in support or opposition to a particular case, as well as any correspondence we've received from other government agencies. At the conclusion of our presentation, the applicant will come first to the table and present their case to the board along with any persons in support of their case. If there's opposition to a case, the board will hear from those parties opposed after the applicant goes first. And then after the opposition has presented their case, the applicant will have a period for rebuttal. In the board's rules, the board provides cases without opposition 10 minutes to present your testimony. To the right of where you'll be seated is a clock that sits on the ledge there. That's the time that you're provided to give your testimony. If the board questions you or asks questions, that clock will stop and will not be running during the question and answer portion. But once you get back to testifying, we'll start the clock back up. In cases with opposition, both sides of a case, both the applicant and the opposition side, have 15 minutes to present their testimony. So if you have multiple speakers, that 15 minutes is not per person, that is per side. So divide that up before you come and work out who's going when and how long they're going to speak. The applicant, if they wish to have their rebuttal time, needs to save some of their 15 minutes that they're allotted up front for their rebuttal. All section numbers that I refer today come directly from the Metropolitan Code, which was adopted by the Metro Council and became effective January 1st, 1998, and applies to the entire jurisdiction of the metropolitan government. I'll introduce and make a part of the record the zoning code, a copy of which is at my desk, and I'll dispense from reading individual sections unless the applicant or opposition requests that I read those sections. The zoning code requires that these proceedings be taped. Therefore, it is imperative anyone wishing to address this board come forward to the table. On your microphone stand, looks just like mine. There's a speak button on the table. Just hit that button. You'll know it's on when the red light's on. Once you get done talking, if you'll turn that off, that way we don't get any feedback on our microphones. The board will go through all cases set for public hearing today, and after each case, the board will vote and discuss that case. The board is vested with the power to act under the cases as outlined in Section 1740-180 of the Metro Code of Law. It should be noted that it's found if anyone's presented false or misleading testimony to this board that may have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The code requires that 4 members of this 7-member board be present to constitute a quorum. The code requires that 4 affirmative votes be to grant your application. So today we'll have 6 members present for all the cases but for 2, and I'll talk about that in a moment. In the event that there are only 4 members present, and we do have a case like that, the first case on today's agenda, there are only 4 members that will be participating in that case. Reason being that case has started, the public hearing is open, it's now been deferred so that the 3 members who were not here at the original date can hear this case. And that'll become important in just a moment. In the event that 5 or more members are present to hear your case and you don't receive 4 affirmative votes, your case will stay on our agenda for the next 30 days. And then those 5 are allowed to change their votes. The other 2 are allowed to review the record and then become eligible to participate. If after that next 30 days you still do not have 4 affirmative votes, your request is deemed denied by operation of law. Any applicant or aggrieved property owners may request a rehearing within 60 days of today's public hearing. Further, any applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within the same 60-day period. After that 60 days has elapsed, the board's decision is final and no further action may be taken. If you're an applicant and your case is granted, it is necessary for you to come and pick up the permit for which you've applied. You have 2 years to pick up your permit after today's hearing for this approval to remain valid. If you don't pick up your permit, you've got to come back here and ask approval. If you do pick up your permit, your permit is granted and the approval of this board remains valid unless the board places some restriction of time limit on your approval. Mr. Chairman, I submit that all cases were filed in order. All applicants were notified by certified mail as required by the code. All affected property owners within 300 feet were notified by first-class mail, and a legal ad was published in the Tennessean. And before we begin, the board does allow elected officials to address the board. Councilman, I know you're here. Are there any other elected officials present? Seeing none, would you like to address the board now or wait for your case? Or
are we the first on the agenda anyway?
I was going to discuss that for a moment. We've got an interesting. Let's do that now. I do have the 4 members present for your case. I have 3 members who cannot hear it and will need to leave the room.
Okay.
I have 1 member who cannot hear the last case on our agenda, and I think we're still fine what we talked about of the 4. So I think we're still okay with proceeding according to our schedule we've got listed here. Okay.
So is the cone of silence outside the room now?
Actually, I've got a place you can go to. It's much nicer than the old building where you just kind of sit out in the lobby, but you do have to leave the room.
You'd rather do the consent first?
Let me do the consent, and I'll bring you right back up after that.
Yeah, that's
okay.
fine.
All right.
Then we can just do the full
Yeah.
figure out.
Okay, the board has a consent agenda, and prior to today's meeting, the board member reviews the case. Today it was Chairman Whitson who reviewed the case, and if in his opinion the application meets all of the criteria that they've requested and they feel that testimony in the case would not alter the material facts of the case, they recommend the case for approval to the remaining board members. So if I'll enter into the record those cases that have been recommended by the chairman, and if anyone here is opposed, please raise your hand and the case will be removed from the consent agenda and heard in the regular order as listed on our agenda. The first case recommended for the consent agenda is case 2012-109. Chad Gary, the appellant, Tamay Ozari, the owner of the property at 3811 Charlotte Avenue. They are requesting a change of non-conforming use to allow the change from auto sales to auto repair. Is there anyone here in opposition to case 109 present? Mr. Chairman, seeing none, this change of use is more in keeping, is appropriate and more in keeping with the surrounding land uses, and you have recommended that case for consent agenda. The next case recommended for the consent agenda is case 2012-110, Mr. David Saffold, the appellant and owner of the property at 3427 Trimble Road, requesting a variance in the rear setback to allow the removal of the connector between 2 homes. Is there anyone here in opposition to case 110 present? Mr. Chairman, seeing none, this is a irregularly shaped lot, and the topography of the lot necessitates a need for a variance in this case. This is the old duplex is connected by a connector. They would be removing the connector and legally subdividing the property into 2 single-family dwellings. The next case recommended for the consent agenda is case 2012-111, NVR Fox Ridge. The appellant owner is the property at 5009 Wolfboro Lane, requesting variances in side setback to allow the legal use of the existing residence as constructed. Is there anyone here in opposition to case 111 on Wolfboro Lane? Mr. Chairman, seeing that the exceptional narrowness of the lot and topography are the reasons for the hardships for the need for the variance in this case. And finally, case 2012-112, NVR Fox Ridge at 1421 Scarcroft Lane, requesting a variance in side setback to allow the legal use of the residence constructed. Is there anyone here in opposition to case 112 on Scarcroft Lane? Mr. Chairman, seeing none, again, the topography and exceptional narrowness of the lot necessitates the need for a variance in that case, and you have recommended cases 109, 110, 111, and 112 for consent.
Okay, so we've got a motion. Have we got a second?
I'll second.
Got a motion and a second. All in favor? Aye. Any opposed? Passes.
If you are here for cases 109, 110, 111, 112, your cases have been granted. You are free to go. And Mr. King, you were the second on that. Oh, Mr. Taylor, I'm sorry. Okay, we'll call the first case. In this case, the following members are eligible to participate. Mr. Harper, Mr. King, Mr. Taylor, and Mr. Whitson are eligible. The other two, if you, after I make the introductions, come with me, I'll show you to your soundproof booth that we have in the back.
No offense.
No offense. Unless you have reviewed the record, have either of you done that? Okay, you're not eligible to participate then. This case is, I'm going to call the case. The councilman will let speak first. This case was deferred. Actually, the board only wanted to hear from the district councilperson before us in that case on the deferral request. But Miss Elizabeth Ellen Siders is the appellant and owner of the property at 1604 Riverwood Drive, requesting a special exception in RS10 to use a portion of the existing residence as a daycare home for 12 children was the request. Referred to the board under section 1716-170. The applicant has alleged the board would have jurisdiction under section 1740-180. And Councilman, before you begin, let me show the photographs to the members to refresh their memories. Members, the subject property is located on the west margin of Riverwood Drive at the intersection of Olga Avenue. It's the property that's bound in red, which you see here. Aerial photographs of the property and the site plan submitted by the applicant at the original hearing. These are photographs from the original hearing well upon my visit to the site, looking into the subject property to the adjoining properties on either side and the play area to the rear. That's the case records. We have it. I'm going to step out and turn over to you, Councilman. And you are, again, not subject to that time constraint over there to your right. So this will
Okay, great. Thank you, Mr. Chair, or Chairman, and staff as well. Appreciate it. Thanks for having us back. And you should have a letter from me, hopefully, from the council office. Okay, great. Basically, I wanted to kind of go over that. And I was going to ask him to pull up one particular photo, but that's okay. Please reference your letter, and if you can pull up a photo, I was going to do the front of the house photo. That's the one I was looking for. So thanks again. We had a great meeting on October 17th, one of those classic neighborhood meetings of everyone coming together, getting our thoughts out, and just trying to come up with some kind of solution for this. Appreciate all the feedback from the last meeting where we were sort of understanding from you guys that the property owner has certain rights, and we wanted to meet with the opposition and sort of come up with what is it that they need to see on the property to make this a workable solution. So we met on the 17th, and I just kind of wanted to go over each individual point with you. No reason to read you the letter there in its entirety, but the compromise points we talked about, first of all, the number of children. Of course, the appellant was going for the maximum 12. We came up with the number right in the middle of where they currently are, between 4 and 12, with a number of 8. Just to kind of keep the traffic down, keep the how much activity was going on at the place. The general feel, of course, from the neighbors is they, being tucked away in Inglewood here, they want this to seem residential still. We understand you can do a daycare home in residential, but really the problem is they want the property to be in great shape, and they want this to still have a residential feel. Otherwise, we might as well go with that full daycare zoning, not just daycare home, you know what I mean? So that was the overall arching theme. So again, with number of children, we sort of came to a middle ground of 8 is where we landed on. Number 2 was no parked cars on the street ever.
I'm sorry, can I ask you a question? Is
Yes.
that 8 exclusive of her children?
Well, that was subject to state law, so we weren't sure we were a little unsure of where that lies. I mean, we basically 8, it was more about the traffic, so 8 vehicles that would come in. So because there was a lot of convoluted information about, when her kids get a certain age, they sort of age out from where they are and and the numbers that count. So we just left it as 8 children maximum that are within age. So
Okay, so I'm not trying to be dumb here, but her children clearly wouldn't be driving up, so we're talking about
Right.
8 kids.
8,
Okay.
yes.
Okay, all right, well, thank you.
no parked cars on the street ever. I think this was a requirement anyway. We just wanted to make sure it was in the text. Or maybe it's not. I'm not sure. We were unsure of that, but we didn't want, with all the parking that was, if we were going to have extra parking, we were going to have a turnaround. We wanted to place a condition: no parked cars on the street. Eliminate the this is one we definitely want to talk through. The requirement for the 2 parking spots on the interior side of Olga. So if you're looking at the house, it's just the 2 that were, and if you looked at the site plan as well, the 2 that are on the left in the photo. That's the Olga side of the property. This was a big one because with 3 spots on the right and a wraparound. I mean, at that point we thought we're just paving the whole yard. If we do these, so we weren't sure as far as with codes you have these requirements, but a sticking point for us was we really want to keep grass. We want this to look like a yard still. That was a key point from the neighbors that showed up to this meeting. So I guess you guys can discuss that, but we really wanted to not have to have the applicant have the 2 spots on this left side here, so that we could maintain some level of yard. Number 4 was applicant must pass the Department of Human Services survey, more state-related stuff, just abiding by all the DHS rules. Number 5, the shrubs and bushes. I said all 4 sides, but really we're concerned with the front 3 sides, the sides in the very front. Basically, this was another key one for the property appearance, shrub barrier, so that if you were looking at the property, you would see a nice shrub barrier in front of the fence, if that makes sense. And for those to be planted by codes with distance and the exact type of shrub that you're supposed to use by the code, because I know you guys usually have certain requirements. Complete painting of the property. There was some, probably a code violation. There was some, mispainted stuff going on, and the applicant said she was working on painting the property, but the neighbors wanted to make sure the property was painted as a condition. The reason it says blending color is oftentimes you may see daycare with a very loud, non-fitting with the character of the neighborhood, bright yellow kind of thing. So just something the neighbors mentioned was a blending color, and the applicant seemed to be on a path to do that, so that shouldn't really be an issue. DHS approved back play area, properly mowed and maintained. Again, should naturally be a condition for running a daycare. No front signage. If we were keeping it as a daycare home, the neighbors thought it would be nice to look residential, to not have signage as a condition. No toys or play equipment visible from the street when the daycare is not in operation. Just a condition of keeping the yard clean. And then one of the neighbors is an engineer, and he mentioned the site should meet grading permit requirements. So not something I know a lot about, but that's just something he said should be in place. Let's see. And then also a final condition after the new driveway, and if we can limit to only the 3 spots, just a condition of no more asphalt or concrete to be constructed or visible from Riverwood or Olga. Again, with the theme of maintaining this as a residential appearing property, something that, the other big thought was if the daycare shuts down or the applicant were to move in a couple of years, that sort of thing, the neighbors are very keen on making it an easy transition back to just a house. If this were to not be a daycare after a while, again, and reading the code, I feel like that's sort of what daycare home is all about. You're not going up to that next level of daycare where you're paving the whole backyard and that sort of thing. So that should go without saying, but these are just some of the conditions that we thought were appropriate to make it an easy transition back to a home should the daycare fall through at some point, or things change and people move on. So love to hear any questions or thoughts you have for me. I guess my time isn't moving, but I don't know how much time I have. But we're not timed. That was the joke. Okay, got it. I'm with it now. Okay, so any thoughts on that, or I'm especially interested in the parking and that sort of thing, or any questions you have from our meeting, just because
Yeah, I think one of the concerns that the homeowner had expressed in a letter was, if the parking requirements were eliminated and there were no street parking, what do you do if 4 cars show up? Where do they go? And so I guess that, those seem like they might have a little bit of a conflict. I understand no street parking on a regular basis, and you wouldn't want someone to park their car for 4 hours, but,
Sure.
If 4 people came to pick up their kids at noon and one parked on the street waiting on their kids, what's more important, the giving up the 2 spaces or having a car on the street? That's
right.
If there's a conflict there.
That may be a question. A couple of the neighbors are here. My personal thought and based on the meeting was that with 3 spots on the right side and the turnaround, that first car is just going to lead in the turnaround, drop the child off, and be on their way. Plus, you've got 3 more on the right side. I just really feel like 5 is overkill. I know there's codes and there's, it's kind of just like with the restaurants, how you guys are like, well, there's this much square footage, we got to have this many parking spots. But I really think in this situation, the 3 spots on the right and the turnaround that you can fit easily 2 cars in would not be a problem. I really don't think there'd be street. It can't possibly happen that everyone shows up at the same time, although, I guess, in the morning they're going to be showing up at close to the same time. But if there's efficiency, you basically have 5 spots with 2 in the turnaround and 3 on the right. So to me, it was important to get rid of the 2 because it keeps it more residential.
Don't we have a site plan? There we go.
So we're talking about 4 and 5, I think. I'm kind of turned around. Yeah, 4 and 5 are the ones that.
Was the applicant at this meeting?
Yes.
She was at the meeting?
We met in front of the house.
Okay.
So we had the applicant, we had all the neighbors.
Could you tell me a little bit about just, what happened at the meeting? And first I want to say thank you for facilitating that meeting. I know it was a really important outcome from our previous hearing, and so thank you for facilitating that, and just help us know who participated and about how many neighbors were there and that type of thing.
Sure. I'd say I'd ballpark we had about 20 folks out there coming and going. The applicant was absolutely there. And then, some neighbors were in opposition. Some neighbors just kind of wanted to see what was going on. We had a very mixed bag of folks. Lance, the engineer who lives down the street on Riverwood, helped me sort of facilitate. It wasn't my traditional way to do a meeting, but I really wanted to be on the property so we could kind of walk through and talk through and just get a really hands-on approach. So basically, I just listened to, we just got all the concerns out. I took really good notes. The applicant was there to answer some questions, and I tried to just do the best I could, sort of referee in this thing. We got a list of what we thought were fair compromises. I tried to not lead into what I thought was the right thing, but really just get the neighbors to say what their concerns were and how we could maybe meet in the middle on this thing. So that's how it went.
Cool. Great, thanks.
Just a question for Joey, I guess. In Codes' view, is 3 parking spots sufficient?
For the land use itself, separating the single-family dwelling, yes. That's actually, when you look at the parking requirement, it lumps the principal use and this use together in the requirement. But if you remove the principal use, 3 is all that's required for daycare homes.
Okay, great. Well, Councilman, I agree. I think y'all have done a heck of a job. This is a nice list. She seems to be in agreement with it as long as she's allowed to have 8 customers, which it sounds like you're fine with, and the parking sounds
That's fair.
fine. So thank you very much. This is very good.
Okay, great.
Great
Thank you for your time.
Okay, so going to close the public hearing. I'm sorry. Oh, I
He
don't.
just was speaking, she hasn't had it.
Did she get a chance? I mean,
Yeah.
No, we were only going to let
we were only going to let the council person.
unless we suspend the rules.
Weren't we only going to allow the council person to speak? Or? Okay.
That's what you had.
Okay.
Okay, sorry.
Okay.
I have a couple of questions for Joy and our attorney. Are signs permitted in this use?
Sure, they're not.
And is there parking allowed on the street now?
There is, unless posted by Public Works, there's not for principal uses and accessory uses on the property. When we talk about the zoning code, it says you got to have X number of spaces. Those have to be on site.
Right.
But as far as physically stopping someone from parking on there, minus signage from Public Works saying no parking, it's not a code.
It's not something we can enforce.
It's not a codes department or a BZA restriction that we can
So
enforce.
it cannot actually be
Public
a park.
Works certainly can.
But they would have to petition Public Works to sign it.
Yes, sir. And as it relates, and I'm sorry I came in late, some of the members here, 3 of you guys may not know, it's been a while since we've had a daycare home before the board, but in your rules, you have also adopted for all daycare homes that the use is for the appellant only. I mean, it's not transferable. They can't sell it to the next owner of the property. The hours of operations are from 6 to 6, weekdays only, no weekend care, no third shifts, no signage, no dogs, no swimming pools. Those are all things that this board has done it within their rules to restrict these land uses. And 3 of you guys may not be, I know Ms. Whitson probably is, Mr. Taylor, you may not be. We just haven't had many daycare homes on our agendas in a while.
Technical question, Joy. Since the appellant, and we were just closing public hearing, right? Is the appellant entitled to a rebuttal? I mean,
No, sir, not under this. You've had the hearing, you've had the original testimony, you've had the opposition side, you've had the period for rebuttal, you've heard from the council member, you closed the public hearing in the original hearing
Okay.
and restricted it only to hear from him.
Did you get her email?
yeah. I do, just primarily that I would like to hear the appellant herself say that she was in agreement with the meeting, you know what I mean?
Okay.
I don't trust the councilman, but I just,
So we've got a motion to suspend the rules, and I'll second. So all in favor? Yeah. All right, suspend the rules. Applicant, would you like to come forward?
Mr. Chairman, for the purposes of your rules, whatever time, I'd ask that whatever time you allow for the applicant, you allow opposition to cover equally. So what we'll do is we'll reverse the timing on it, let it count upward. That'd be the easiest thing, then turn around and flip it, let it count down when she's done. The zoning administrator wanted me to point out parking, as you see here, we do allow stacking or double parking on a daycare home use. The idea of the principal use is residents, you can stack cars behind each other on that, so they don't have to be in a traditional parking layout like you see out front.
well, I move that we give the appellant 3 minutes for rebuttal time if she'd like, and the same thing back for the,
Let's just do that. I second that.
Okay, got a motion, got a second. All in favor?
Aye.
Any opposed? None. Passes.
If you're answering a question, that doesn't go against your time.
Oh,
So
okay.
we're just giving you the 3 minutes. If you decide to, have a soliloquy or something for 3 minutes.
That's all. Thanks.
So are you in agreement with these terms?
Well, I did write a letter to the board
Right.
of a few that I was not clear about, and it seems like what you have come up with is clear about the 8 children. I was confused about what does that entail, because when you go through DHS, they give you a specific number. So I wanted to be sure that in this compromise that it, I'm going to be okay as a business. Not saying that 6 children wouldn't give me income, but 8, there's a difference there. So that all makes sense to me, that I can have 8 customers other than my children. Right? Okay. And the parking, when you just explained it, it made sense. I'm still confused about the parking on the street, because it seems like in the past I have been called in from for a violation of parking on the street. So that's where I'm like, I don't know.
Well, I can help you. Parking is prohibited on the street, period.
Right.
And so you need to tell your customers they can't do it.
Right.
And if they do, you're the only person they can call, is what it comes
And there
down to.
was never anyone parking on
But
the
Chairman,
street.
I'm not sure that's true. I don't know that we can do that, can we? That was going to what I was asking earlier. I mean, unless Public Works posts no parking, help me out, Chairman.
It doesn't help at all. I would note, just for what I think will be clarification on the discussion you had on that point earlier, this board certainly doesn't have the authority to, and I know it's not what's specifically requested here, but to grant permission for street parking in an instance like this, nor would you be able to find some sort of a creative solution to your parking situation that necessarily included street parking as kind of a shrug of the shoulders, well, but they can do this or that. Absent specific permission to park there, i.e. signs posted, you can't. As a practical matter, given that this is an unusually angled intersection with Olga Avenue, you shouldn't.
Yeah.
And as a result, there may be some other actions the board can take, but those actions would not be able to include street parking as part of the solution.
Because I think if we said that we expected no street parking and they had evidence of lots of street parking, then that would be a reason for the neighbors to come back and say, we'd like for you to review your variance request because they're not following your guidelines. Is that correct?
I think potentially so. And as the zoning administrator, Mr. Herbert, aptly noted, I think it's actually state law that would prohibit that type of parking and therefore trigger some of those concerns that Mr. Taylor notes.
And it's actually in our requirements for daycare homes. So anyway,
So stacked parking can work in this situation too. So that's like that all works out for me to stack either like up, because we still haven't figured out the. We have to get through this first to be able to figure out, actually doing the turnaround and everything, and having the 3 parking spaces on that one side. And I guess taking away the 2 so they could stack in the turnaround, and because that will keep flowing. And usually nobody parks anyway.
Well, and if I remember, there were multiple children for certain households and a few walked, and so 5 should be plenty.
Yeah. And the shrubs, that was another question, because in the compromise letter, it was the 4 sides, and I was confused on what that entailed. Where am I going to have to put shrubs? So that was taken care of. That was cleared. So I'm in agreement with, all of those compromises. And
Any questions?
Not for me.
David, you good down there?
the sign. I am in agreement, but I'm also, as a business owner, a little, I would like to have a sign, but it's something that's not.
Yeah, I don't think that's in our purview. I don't think we can allow you that. I think it's against the rules now.
No. I mean, it's under our own rules about what can be allowed. There are no signs.
No signs at all?
Yeah, that's under the code.
I
That's under the
okay,
code.
so for centers, because I was like, why do other daycares have that? Those are okay.
Right.
Gotcha. Then that's okay.
Okay, if there are no questions, would the opposition like to speak? I'm sorry, can you come forward? We need to get your name on.
We can't hear you. Yeah, we don't exactly know what Beth's talking about here. As far as, parking place, you have to have, they're gonna get parked on the think we couldn't really hear what
Sorry.
Okay,
she was talking about.
I'm sorry. I'll try to be as clear as possible. Everything in the councilman's letter is going to be a condition to our agreeing to this, except we're clarifying that it's 8 children exclusive of hers, so there could be 8 paying customers. She will agree to taking out the 2 parking spots, and it's now clear what type of shrubbery she needs along the sides of her house. So essentially, we are adopting the councilman's conditions as conditions to our, well, hold on, I'm speaking too quickly. We may do that. we haven't voted on anything yet, but that's the proposal in front of us.
That's what.
Right.
And we'll get a letter of what y'all got. I guess what is that letter they're talking about?
It's
We got it. We already got that one. Okay.
So all those are, I'm saying I'm in agreement because I had written a letter to the board because I was unclear about a few of them. So that's what we were kind of, to make sure that I was in agreement now. So I'm in agreement to all the compromises.
Yeah. Could you introduce yourself again, just for the record?
No, I'm best neighbor.
But your name, if you could, please.
Strong.
Okay, thank you.
I was just wondering because I couldn't really hear what she was saying up there.
Sorry.
That's fine. Thank you. Okay, unless we have any questions, I'm going to move to close the public hearing.
Second.
Okay, great. We're going to close the public hearing. Discussion.
So I don't know if we need to enumerate these in a motion, but obviously number 1, I don't think number 2 should be a part. I don't think we should put conditions in that are already code required. As a matter of practice, that seems redundant and potentially dangerous. So to me, 2 would not be part of the motion. 3 would be. 4 would not be. 5 would be. 6, I'm actually opposed to putting into a motion anyway, but that's for the committee's consideration. I don't think 7, as it is, necessarily has to be in the motion unless we are saying that the play area has to be in the back, which seems to be the intent, that they don't want it in the front yard. And number 8 would not need to be in there, and I think number 9 goes back to what I was saying about number 7, and I think 10 is also redundant and would not need to be in there, and 11 would be a part of a motion that I would make, if all that makes sense.
Yeah, I mean, and your goal is to achieve these 11 points, and I think you said with more discussion maybe for number 6, but the ones that you'd mentioned were important to put in the motion because the others are already included in current rules or law.
Correct. And that's
so that they have to abide by the others, regardless of our action.
They have to abide by all codes.
Just so that it's clear to the folks here that we're not trying to make them not abide by those items. It's that they're already included in current rules or law.
Yes, correct. And and my thought on number 6 is it seems too vague to be enforceable anyway, and it sounds like that she's painting, and I wouldn't know how to write a specific code or a specific motion to tell her what color to paint the house or what color she couldn't paint the house. Nor do I think it's our place. So.
Yeah. But well, the one thing about it, and I do understand. I think if it's something that had not been agreed to by all parties, then it might be something that I wouldn't necessarily support. But since it is something that since this was such a contentious case, and it definitely appears that the property owner and the neighbors met and really talked it through, that I don't have a problem in putting that in to give folks I think it basically means that there'll be maybe a second or third thought about, what color you really paint the property, so it's not a, bright blue or bright green or whatever it was that they had said.
Maybe we could just reword number 6, something like, rather than blending color, just something harmonious with the neighborhood, or harmonious with the residential neighborhood, something like that.
Well, and part of my problem is a technical problem, but part of it is also philosophical. But I can see that, what if her next door neighbor decided to paint her house or his house bright orange? Then we've opened the door to allow the daycare to paint their house bright orange because it would then blend with the neighbor. That's what I'm saying. There's no way to be specific about what we are or are not allowing, even though they've agreed on it in principle, but it's not going to hang it up for me. It just seems like an odd requirement to me.
Yeah, I agree. It does seem odd, but to me, just in the spirit of, boy, we've had a lot of people go work together.
Sure.
And I think, well, what is the recourse? I mean, if it was a color that wasn't viewed appropriate by the neighbors, I would suppose they would have to, bring it back for us to consider, and then maybe we're in the paint color business. I don't know that I want to do that, but I think that it would be a pretty tough sell. I think for me, if the initial painting was agreed to, that it would be a tough sell to come back to us and say,
I don't know if we have the authority to do such.
And maybe not.
Well, I asked our.
Mr. King, we were just talking about that a little bit, and the zoning administrator, Mr. Herbert, quickly pointed out under chapter 17, 16, where you get into some of the special exception language, it does speak to materials and colors as being part of the general guidelines. I don't know how well that sticks in courts. I've not read case law on that one way or the other. I know in the past this honorable board has tried to steer clear of the business of not regulating ugly, and whether we thought it was or wasn't or whatever else. But very generally speaking, I am not aware of how that would be upheld, challenged, or otherwise treated by courts if appealed. The code does contemplate color to some extent, but as has been rightly noted by Mr. Harper at the beginning of this discussion, it's a little vague as written and might, be subject to challenge.
Not only do I want it to be something that's subject to challenge in court, I don't want it to be something that somebody gets taken to court over. I mean, it just seems that doesn't blend enough. That's not green enough. That's not brown enough. I mean, and like I said, I guess the recourse would be to come back to us or court. And it's just, I don't know. It seems to me they have an understanding. And I mean, are we gonna negotiate all neighborly functions and relations? I mean, it just seems.
I would say
that's the tipping point for me.
In that case, based on what our counsel is saying, that's covered by the code anyway. So. We strike that as redundant and comply with the code. How's that?
That's true. I mean, it has to be compatible with the surrounding center. Compatible with the has to be compatible with the neighborhood, and so it is part of the general conditions. So I think that's a good point that it is redundant. So why don't we just strike 6 as well? David, do you want to make that motion?
God, I was hoping you would ask me. This is I don't have my cheat sheet, but and it's a special use or a conditional use.
A special exception.
Special exception. Well, I will take a stab at it, and rather than referring to the numbers in the letter, I'll just say them or reword them, and then we can fix it. I move that in the case of 2012-092 that we approve the special exemption with the conditions that there be no more than 8 children, which excludes residents of the property, that only 3 parking spaces are required on site, shrubs and bushes on the, and you will have to clarify, was the goal to get it on the street or enclose the front yard with the shrub?
The street and 2 sides.
Okay, along the public street and the 2 sides of the front yard of the property. And that all daycare-related toys and play structures be limited to the backyard, the rear of the house, and that no more paving than the initial parking and drive and turnaround required herein be added later without further application for variance. Would that be correct? Ish?
Second. Got a motion, got a second. All in favor? Aye. Any opposed? Good. Passes. Thank you.
Thank you. Not trying to be a stickler, just
And this really was a great example of neighbors
Yes,
coming
thank you,
together
Councilman.
to work out a problem that could work for everybody. So, Councilperson Davis, thank you again very much for your work.
All right, Mr. Chairman. The additionally, members and the folks here, these 7 conditions listed on the screen are also incorporated into your order that will be written. Fence playground required, no signs pertaining to the daycare. Appellant must live on the premises. Hours of operation restricted. Mondays, Friday, they're right out there. No dogs, no swimming pools, and for the applicant only. Those additional 7 will be added as well.
Joe, did you say there was a case that one of us couldn't hear? Oh, it's Mr. It's not me.
You can always make it yourself.
The board will take a,
You guys heard it now.
members, just so I can get the other 2 in here and get situated, let's take a couple-minute recess, please. Thank you. Board will be adjourned for a few moments. Appellant, excuse me, sir, gentlemen. No, you're good. Thank you. Mr. Smith, are you present? All right, if you'll come forward, please. Any other folks you'd like to speak on your behalf, come forward. Is there any opposition present? There is none. Okay. Mr. Smith, you'll have 10 minutes to present your testimony. I'll go over all of our side first, and then I'll turn it over to you. Mr. Smith is the appellant, Mr. James Clayton, the owner of the property at 333 Swinging Bridge Road. He is requesting a variance in the required parking in CS to construct, actually should read, to allow the legal use of a 24 by 48 covered patio addition to the side of the existing bar. This is referred to the board under section 1720.030. The applicant has alleged the board would have jurisdiction under section 1740.180B. Let me step back and I'll show the photographs and such to the members. Members, again, this case is before you on a parking variance. We have received a comment from Traffic and Parking. You have copies of that information that they've sent over. The subject property is located in red. You see here it is in the CS zone district. To the immediate northeast is the DuPont factory and plant there. The adjoining property is vacant. Railroad tracks separate this parcel from the parcels to the south. The parking variance required based upon the square footage of the addition that's here, as well as the existing square footage and covered seating areas, which you see there. There are 40 parking spaces required of the applicant. Proposed on site that are usable, and I'll explain what I mean by that. The 3 spaces located to the rear here are not able to be accessed. The 23 feet that's here, you'll see in the photographs a dumpster pad located. You just will not be able to reach these spaces here. So the 17 number that I have here includes the 8 spaces which you see along this radius here, curvature, as well as the 9 spaces that are front loaded or head end loaded off Swinging Bridge Road. The edge of the pavement, as you'll note in the photographs and you'll see, is a pretty good ways from the back of where these cars are. This area here is a graveled area. We would require the applicant to pave this area and hard surface this area over here for these 8 spaces. So 17 total with Public Works approval. Public Works is, in their comments, I believe, hopefully Devin addressed with you the front pulling in spaces. They, in discussions with them, they're going to discuss that with them on the permit side. My understanding, they're at least their initial indications to our office is that they're going to be okay with these coming in, given there's such distance that you'll see from where the cars end up parking and the distance between the back of the car and the actual pavement of the street. There's pretty good ways there. The applicant is proposing this area, which you see here, it's concreted, and to have 40 spaces for motorcycle parking. The gentleman's clientele is generally bikers that come to this bar. They don't drive cars, they do drive motorcycles, and he's set aside 40 spaces for his clients and visitors to come in, which you'll see on the photographs too. This is looking at the subject property from Swinging Bridge. The existing bar building is located here in the covered seating area that there in this location. Those were existing. This is the addition that's been erected on the property and triggered this need for parking that's out here. The concrete area which you see located in front of the building, in other photographs you'll see are striped, angled parking here, 90-degree parking for motorcycles. Again, this is looking back toward the railroad tracks. The 9 spaces that I talked about in the site plan on the other side of this fence here, in this area, as you'll note, is as cars pull in off of Swinging Bridge Road and pull up to this fence area and the retaining wall and gate here, there's significant enough room for them from the back of the parking cars to the actual pavement of Swinging Bridge Road. But Public Works will talk with them about what they may want them to do, maybe perhaps angle those parking spaces in rather than 90 degrees. This area appeared to me on my visit to have been recently graveled, perhaps re-graveled from prior. We will require them to surface this lot here as well as this. This is the radius area that I was talking about, the 8 spaces.
Joy,
to the right of the site.
It has to be a hard surface?
Yes. This area here especially, in looking at the aerial photographs, we go back in time and sort of look to see what's out there and see if any substantial changes. This area, which I'm noting by moving the cursor on the site plan, this has been recently gravelled. This has not been here. There may have been a small patch here or there, but older aerials show this. This is mostly grass. So this area needs to be surfaced. This area as well needs to be surfaced. There was some gravel out here, but it doesn't appear. It would have to go back to 1974 to be grandfathered on the gravel area. And I can't, none of the aerials I go back that far show those 2 areas to be gravel.
So you're allowed no gravel parking?
You're essentially not for changes of use or new uses. You're not allowed gravel unless that gravel parking lot existed prior to Christmas Eve of 1974, which you would be grandfathered then.
Okay.
So these areas would be brought up to compliance with hard surface parking. This area here is already concreted. That has been that way, it appears, for some time. Maybe recently touched up there. And then views of this is the back of the property. Looking, this was the area that perhaps 3 spaces would be located. As you can see, just access to that area is going to be restricted. And there's not enough width between the back corner of this home, this structure, and the actual property line stake, which you see there, wide enough to allow them to even access this area. I want to tell you while the applicant's with me to ask about the RV. What's the situation there? Someone residing in that? There appeared to be a power cord hooked up to it.
Yeah, it was, but not now.
Okay. Okay, good. I didn't see evidence that anyone was living there, but it may have been being charged or something. We just want to be sure that does not occur. I'd noticed in our property records back in 2008 that a citation was issued to a prior owner, perhaps living in an RV on the property. So that's really all we've got. Hopefully, Public Works, you got their comments. I don't have them in front of me, and I'm sorry. I could address any of them. But with that, I'll turn it over to the applicant. This time, sir, you'll have 10 minutes along with the gentleman with you to present your testimony.
Afternoon, everybody. Gentlemen, ma'am. I'm Don Johnson, principal partner of Triad Construction, longtime friend and business associate of Mr. Smith. He just asked me here, we'd done a little bit of research on this, and he's worked hard to try to get this thing up to speed, and I think it's important for us to express the fact that the prior owner's disregard for the permit process has put us in this situation. The 24 by 48 addition, obviously you saw in the photos, is in place. This property was purchased at auction due to a demise of the previous owner's friendship or partnership, and was purchased in that state. They've made every effort to obtain the lot to the right of that, which is parcel 193, and actually had terms on that and to avoid, to meet everything that we needed to meet. Unfortunately, that property is tied up in a tax lien situation, which has forced him into being here and asking for this variance for parking. Albeit a very unscientific formula for him was the fact that right now his clientele are about 3-to-1 motorcycle enthusiasts. And I understand that Metro really doesn't recognize a difference between a motorcycle and a car when it comes to parking. And the short of it is that we would like for you guys to consider that and considering the patronages of this area. And Mr. Smith has also, I believe, furnished a letter from the Chamber of Commerce and welcomed him into the area and all that. And I can honestly say that I know personally that he's put a lot of effort into bringing this thing up to speed and trying to do everything, quote unquote, by the book. So that's really about it. That's kind of the short and sweet version of it for that goes. Like I said, he was kind of forced into this situation, and think that he's talked to everybody and did everything that he could, and was pretty much put on you guys to kind of make that final decision whether this is a workable solution or not.
Yeah, and who owns the property?
Gary and Michelle Ely own it. That's the name that's on here now, as prior y'all's system wasn't updated in time for the variance.
When was it purchased?
September the 20th is when the property was purchased.
And is there a contract for the land next door?
Well, there was to buy it, and then there's $100 and something thousand tax lien on it, and it's got to be either paid or the IRS will have to settle it.
In the property next door also, there was going to be a lease in place, but from our understanding, that lease had to be 3 years and documented and registered to help meet these requirements. And obviously, with the tax lien over it, that's not a very viable option for them. And still not ruling out that piece of property, depending on if it goes up for auction and all of that, just depending on how things shake out. They very much want it, but there's no guarantee with that, given the current situation, and not even any type time frame that would that we could even say, hey, in 6 months we're going to have this, because that just wouldn't be reasonable that we could make a statement like that.
And how long is your lease? How long is your lease on this property?
It's 12 months.
And do you have rights to renew, or is it just
Yeah.
And then how long would be how long could you have the property through your rights to renew?
It's indefinite. It's meaning that the first 12 months is the lease, and then after that, there's going to be terms set for Mr. Smith to purchase the property.
Okay.
Considering it was bought at the auction, they want to keep it there 12 months for obvious reasons, for capital gains and so forth. So Mr. Smith agreed to lease the property for the first 12 months, and then after that, go into negotiations to buy it, whether it be financing or owner terms.
I just have one question. It looks as if the reason you can't provide the required amount of parking is because of the odd shape of the lot.
Yeah, not a very conforming lot to what we've got going on here.
It looks like you're surrounded by railroad tracks, too.
Right, and we've actually had it resurveyed since the time. Mm-hmm. And the original guy that surveyed it was 20 and 30 feet off front line to back line, because it actually clipped the corner of the concrete on the existing building now, where it's way out away from it, or you couldn't even get around to the back of the building if you put a fence on it.
Okay. Well, thank you.
I realize bars aren't attractive to most neighborhoods, but the fact that really haven't had a lot of opposition to this, and considering its location right across from DuPont and everything, and it's just the very, very odd shape of the lot.
Well, the photographs look like it's a nice, it looks like it's a nice building and nicely kept.
So how do you attract motorcycle enthusiasts as opposed to people with cars?
We run with a lot of them ourselves. we do rides and events, and when we do that, I mean, that's basically all it is. We've had all that parking in the front. We've been open now on the other side for the last 28 days or so, and we've had that parking lot in front, nothing but motorcycles.
So if
even
I owned
to the other side.
If I owned a motorcycle and I saw a bunch of motorcycles out front, I'd want to go to that place because there are other like-minded people.
I guess.
Well, I said motorcycle enthusiast because nobody likes the term biker bar. It just has a certain negative connotation that goes along with that. Mr. Smith has a couple of motorcycle clubs. The guys that'll meet on the weekends, they'll come out, they do their rides, they do their toy run things. And the previous owners opened this under the same name as Scully Saloon, and really did a really good job actually marketing it as a biker bar. I believe it shows up on some web searches and stuff as Nashville's #1 little biker bar and all that. And, you know, you got a nice bike, you want to show it off, you know, you want to go somewhere where people would appreciate it. So, and the numbers that we had been keeping up with since we found out about this hearing on the kind of the car to bike ratio have been in not very conducive weather to riding a bike. So obviously spring, summer, that you know, we think that ratio will only increase.
Do you know anything about the history of the building, business-wise?
It's been a bar since the 50s or 60s. Feller Brown's dad actually owned it at one time, which was a councilman. It was a feed store, and I think it was a gas station even at one time. That's been many years ago. It's been a bar all my entire life. And we was talking about the parking. The parking on the upper end, ever since I can remember, is always on that left end has been graveled. Never been no hard surface. The other end, I actually touched up the gravel that was there after we got it.
Okay, for the record, I'm personally not anti-bar. So anyway, any other questions? Any other questions? All right.
I know where it is.
I
know where it is. You have the jacket for it. I think you should go.
All right, we're going to close the public hearing. Discussion? Well, I will say this. I mean, Public Works thinks it's a good plan based on the clientele, and it's clearly an odd shape. And
I don't have any issue with that. My only thought that I'm kind of thinking through is do we impose a time limit to say, you know, since there is an ownership transition, you know, kind of in the works. I mean, is this like a 2 or 3 year thing just to see, you know, I know they're trying to buy the property next door. If they buy the property next door, you know, you would assume that they would expand that parking lot. You know, I mean, it's just a question. And if otherwise, I mean,
no, I mean, I think that's something to consider. And as the only owner of a bar on this BCA, I would defer to your kind of judgment.
Well, and it really wasn't. I mean, from that perspective, but it was, you know, where do people park? If, you know, the more popular it is, the more need for parking. And I didn't see from the photographs that, you know, just a lot of overflow parking opportunities. I think what was expressed and what I would agree with if I were the property owner is I sure would be trying to get the property next door. And it sounds like as they work through those liens and other issues that may be very likely. And so that, and it just something that felt like, you know, again, not to hamper long-term business growth or their ability to use the property, but the question, and that's why I was asking about the lease and how long he had the property, was to say, well, is this something that we want to permanently attach to the property, or is it something that we want to provide for long enough to give them comfort to, hey, I can do my business, you know, at least for X number of years, and then things probably will change based on what we've been told, and then I would just need to come back to the board and say, you know, hey, if things haven't changed, I still have a weird shaped lot, I still have a lot of bikers, I'm doing exactly what I was doing when I told you 3 years ago I needed the variance, and you would expect the variance to be granted again.
I think it's unfortunate there's not a consideration for number of bikes that can be parked versus number of automobiles. I mean,
yeah, I agree with that.
Almost I don't have a bike, but I'd say at least 2 to 1, but.
I would just want to make sure that if we tied that into some type of time period, that it wouldn't be something where they face the unknown with a different group of people and they come back 5 years from now or 3 years from now and they re-explore the whole reason why we do this. So I just would be concerned if you put it on a time period that they would have that uncertainty before them, but there may be a way we can work around that.
Well, and that's true. And I don't feel that strong. I mean, I'd raise it as a question because it came to mind, but I certainly wouldn't be opposed to a motion that just granted it as is.
Could it then be tied into, since I guess they're leasing the property, could we tie it not to the property but to, I guess, to the tenant?
Yes, I would be interested in. Maybe we're saying the same thing but from different direction, but this seems adequate for this use in this configuration, and I would be willing to say, yeah, as long as this is what you're doing, this is your property, it's cool. What I wouldn't want is for some reason they sold it and somebody decided to make it a pancake club, and we've given it to the property and not the owner, but the use technically hasn't changed.
Yeah.
Then the pancake fans wouldn't have enough parking. So I wouldn't give these guys the benefit, is what I'm trying to say.
So basically, as long as Bobby Smith is the tenant or the owner of that property, then that variance would apply.
That's what I'm saying, right.
Okay.
That's what I'm.
Yeah.
Yeah, I think that achieves what I was trying to do, too.
Motion?
You should.
Right. See if I can get this one right. Let me pull up the case number. 13. All right. I would like to move that that the variance requested for case 2012-113 be granted based on the odd shape of the lot, subject to, how are we going to say that? How are we going to say that? Subject to the owner,
to Bobby Smith being the tenant or the owner of the property.
Correct.
Or applicable only to.
Applicable only to Bobby Smith owning the business that leases the property or owning that property.
I'll second.
Got a motion, got a second. All in favor? Aye. Any opposed? Passes. Congratulations.
Thank you.
Yes, good luck with everything.
The next and final case of today's agenda, case 2012-114. Mr. Chris Choate is the appellant. Mr.
Joey,
yes.
This is a case that a partner in my law firm is handling, so I'm recusing myself.
The record will reflect Mr. Ewing has recused himself, and since it's the last case, you are free to. Yes, there you are. Mr. Choate, the appellant, Alton Brooks Parker, is the owner of the property located at 511 Buchanan Street, requesting variances in street, side, and rear setbacks in R6 UZO to construct a proposed horizontal property line regime duplex with detached garages. Referred to the board under sections 17-12020A and 17-12030A. The applicant has alleged the board wouldn't have jurisdiction under section 1740-180. Item B. Is anyone here in opposition to the case? No, Mr. Lubarsky is here in support. Sir, you have 10 minutes. Let me go through the slides for them. And Mr. Choate's also turned in a PowerPoint presentation. I'll get that queued up for him. The subject property you see is located in the R6 district. It's the red parcel listed here. This will be at just east of Buchanan Street on in between 5th and 6th Avenues North. The subject property of the home that sits there today and the adjoining property. This is the site plan submitted by the applicants requesting 3 variances. The first being a street setback variance, the minimum required setback for this structure, and you'll see in the photographs the existing home that's on there. Once that home is destroyed or demolished, it's not allowed to be counted or considered to so essentially, when you take that structure down, when you rebuild a structure, you have to conform with the front setbacks of today. The front setbacks, what we've figured out to be approximately 26.5 feet based upon the adjoining residences on either side. He's requesting a 5-foot setback off the street So a variance of 21.5 feet there. The second variance was a side setback variance along the western property line, not only for the residence that will be located here, but also the detached garage here. On the residence, the required setback's 5 feet, proposing 2. The graphic should also say that the required setback for the detached garage, based on its size, is 5 feet. And the 3 feet, and requesting 2. So again, 3 feet setback required for this garage. Because you have 2 garages back here, detached structures, the code only allows for a single structure to be granted a reduced setback on both side and rear setbacks. Meaning one of these 2 garages has to sit 20 feet off the alley. In that one case is what we're listing as this garage as being the needed garage to be 20 feet off the rear. It does conform to the side setbacks over here because there's a 10-foot easement along the eastern property line. So there's a rear setback requirement of 20 feet on this structure and 10 feet on this structure. And then again, the rear setback you're proposing, Mr. Cho, these are rear-loaded garages coming in from the alley?
Yes, sir.
Okay. So there will be a rear setback on both structures. Let me back up. This structure must be 20 feet. This structure on the western side has to be 10 feet off the alleyway because it is rear-loaded. So you have a variance there from 10 to 3 on this structure and from 20 to 3 on this structure.
So if they were connected and it was one garage, would it be too big?
One garage would be over 700 square feet and would need to be 20 feet in total off the rear property line based on that size. So detached structures can, under 700 square feet, get setback reductions. On garages, depending on where the garage door faces, if it faces internally or faces a side property line, then it can sit 3 feet off the alley. If the garage doors face the alley, it's got to be 10 feet. And then any structure over 700 square feet has to be full setbacks for the zone district 5, 20 off the rear. Just looking at the subject property and the existing residence that sits here today, you'll note the residence does sit pretty close to the street there. These are the adjoining homes. This is the one on the west side, the home on the east side. And the required setback for this new structure is the average of these 2 homes, which we've approximated about 26.5 feet. This view is from the alleyway. This is the adjoining property to the left. This stake, which you see here, is the back corner of the gentleman's property. And the garages would sit in this area here. Another straight-on shot from there. So you have 2 garages sitting at the alley, garage doors facing the alley, both of which requesting to be 3 feet off the alley instead of 10 and 20 as required, and then sitting a foot too close on this sideline here on this garage. Okay, Chris, I'm going to back out of that, and I'll turn it over to you, and I'll get your presentation.
Just a factual question. Where is the sewer line?
The sewer line itself is located in this photograph, and I'm sorry I don't have one straight on, but it would be on the left-hand side of this photograph here, running through this area. In this bottom right photograph, you'll note the survey marker here is the property line. So that sewer line easement runs from this point 10 feet into the property. The actual location of the line I'm not aware of, but there is an easement there.
Joey, how far is the house now from the street?
I would call it an educated guess, Mr. Taylor. I'm going to say about 5 to 6 feet. From the front wall of that home to the sidewalk today. All right, I'll turn it over to you, Mr. Choate. If you'll just let me know when to proceed through the slides, then I'll get it ready for you.
Thank you for your service here. This is what we want to build on Buchanan. We purchased the property about a year and a half ago, and we did all our due diligence. I mean, we were very prudent. We met with Metro Codes. We met with Water and Sewer Department. We even had Tennessee One Call come out. And if you look at the next slide, this shows what Metro has on record. Well, yes, they give you a warning, a caution down at the bottom saying this is not perfect. Well, I asked them about it, and they said, yeah, they can be off a foot. Well, Mr. Lebarsky, who's my neighbor over there, met me and my contractor out there when we were looking at building some houses there, and he said, you know, I'm an engineer, and I'm your neighbor here. I want you to build the houses, but you might need to look at that sewer line. I was like, well, I got Metro's map here. So I called the surveyor, and the surveyor came out there and said, yeah, they're a little more off than a foot. They're about 15 feet off. And if you go to the next slide, you'll see here that the sewer actually goes through the right-hand side of the property. And I have to stay 10 feet from the center of that sewer line. Well, the property is already very shallow, so we were just stuck in this situation, and we're trying to figure out everything we can do to not really hurt ourselves with this property because we've already purchased it. So we started driving around the neighborhood looking at it, and you go over to like Germantown Village or Germantown Station, and they have all these houses built to the curb. So we decided we'll build something to the curb, and ideally we'd like to build 1,700 square feet, a 3-bedroom, 2.5 bath with a 2-car garage. It's just impossible. So we've decided that we'll go down to about 1,435 square feet. We'd love to have a bedroom downstairs. We can't do that. We're willing to move it upstairs. We're willing to build a lot smaller house. And then if you look at the right-hand side where that sewer line comes through, there's no way of attaching a garage to the house back there. The garage just will not fit there because we have to stay off the sewer line that we didn't know even existed. The truth about the sewer line, it's not on public record anywhere. There is not an easement anywhere. Title search, nothing pulled it up. I mean, it just was there. It was just a surprise. But, to walk around the property there, the neighbors to the left from here, they're 17.5 feet away from the property line. So, and they also wrote a letter in total support of it. They're 17.5. Normally it would just be 10. Mr. Lebarsky's house is 13.3 feet to the right. No harm done there. The houses are 5 foot from the center. And then I'll show you here in a second, the garages, yes, we're asking for 3 feet. But there's also like 6 feet 10 inches and then 7 feet 10 inches of public right-of-way between the alley and where my property line starts. So yes, we're asking for 3, but there's going to be an additional 6, almost 7 feet there. So again, there is going to be 10 feet there. Next slide, please. That's what we want to build, and the next slide shows what we're tearing. This is what we're tearing down. This is why Mr. Lebarsky's here today. This is what he sees every day. Next slide. That's his view right there. Next slide. Next slide, please. Okay, and then there's conversations going, okay, you're pulling back into the alley. Well, this is 3rd and Madison. This is an industrial building on 3rd and Madison. All you have is a sidewalk. They pull out of the garage. And the next couple slides will show additional pictures of that, of people pulling off. This is a brand new development at 4th and Madison. Multi-tenant development, garages pulling right into the alley. I mean, you have 3 or 4 feet until we hit the alley. I'm still asking, you'll still have 10 until you meet the alley. You can flip next slide. 6 in Garfield, over and over again. And where it's cantilevered out over there, I mean, there's like 2 feet until you actually hit the street. And again, we're at 10. And our goal here is to give the community a nice home. And we would like to have a backyard. I believe it's a hardship for a city, a family not to have green grass in their backyard. So, but this right here shows the difference between the property line and where our alley actually starts. That stake there is 6 feet 10 inches. Next slide. That stake there is 7 feet 8 inches, and we're going to be 3 feet on the other. This is the problem we're having throughout the neighborhood. This is a neighbor behind me. The builder actually didn't budget for the additional 15 feet of concrete, so they pull in off the alley through gravel into concrete to get into their property, get into their garages. Flip on through. Next slide. This again, these are letters from the neighbors. That's Mr. Lebarski's letter in total support. That's Mr. Harvey's letter. I really like what he said. I like the houses being close to the street. I really like how they pulled the garages to the alley to allow for green space in between the houses and garages. Neighbors, families, and children need green grass to grill out, to walk their dog, and to play. Next slide. And this is what we ask you to allow us to build.
Questions?
So what's the hardship on the front side?
The sewer line, because the sewer line just takes huge amounts of the property away because we have to stay 10 feet away. I mean, the lot was 64. Time we take that, I mean, it takes 13 feet there in the, at a certain area of our lot away. And we're trying to give the appearance of a single-family home, and there's just not enough room. I mean, our houses are already 22 by, I cannot see it from here, deep.
Yeah, and they're two-story houses?
Yes, sir.
And how big, I mean, when I looked at the 22 by 42, I guess those are outside walls to outside walls, so I got like 900 and something square feet, but I guess a little less if you were counting the inside square footage.
That
would be 1,800 and something square foot a house, just for the house part if you had 2 stories.
Yes, sir. There is a front porch, like a 6-foot front porch, and it's only on the first story.
Yeah, I mean, when I look at it, it does seem like it's a stroke of bad luck to have the sewer line come through, and I do like what's going on in Salem Town. It's really evolving nicely as a neighborhood with a lot of new development and fixing up some of the older houses that are there. But I do raise the question of, why is it important to have these row houses instead of, an up and down? If you are zoned for a duplex or 2 homes, and they could be up and down, they could be front to back. It seems like this hardship is trying to impose this plan on, with that variance. And I was wondering if all the other creative options had been exhausted. Why does it have to be these townhouses instead of a front to back scenario where you could pull in off that, you have a driveway where that easement is?
We have looked at the different product in the neighborhood, and we're trying to build something that fits. Even these plans kind of go by the historic standards, and that's what we're trying to do, is just give something that matches what's already being built in the neighborhood. Because that neighborhood, I mean, you have the historic, but then you do have condos popping up, and you have all different styles. But I'm just trying to keep the traditional Germantown, Salemtown neighborhood.
Yeah, and I appreciate the look and feel of it, and it does fit in with a lot of what's going on there. I do respect that. I just, like I said, when I look at it, I ask myself, do they have to do this, to get what you want to achieve out of the property? And that's where I was asking that.
I feel the same way. I feel like trying to get 2 parcels on the lot for a single parcel. To me, like, you could eliminate one, you wouldn't have all these variances. So I feel like it's a sort of a self-inflicting hardship, if there is a hardship, I don't really see the hardship. So I agree that the sewer line can be a hardship. But I think there are other solutions than cutting down, going for 3 variances on this property is a bit much, I think, personally.
Yeah, one of the issues that I was having on this too is just the 2-foot variance, and I understand you're 17 feet from the existing house, but it and I don't have a frontal picture of the existing house. It would be to the left as I'm looking at it, I guess to the right from the front. But it I don't know how new or what about, is it right for someone wanting to buy it and put in the same type of duplex, and I'm not sure if that's the right term, but to build 2 homes on that property, how that 2-foot variance on yours would impact, their ability to do that. And, very much appreciate that it's 17 feet now, but if the trend is that homes like that are being bought and torn down, then I do worry about that 2-foot variance on the side.
The existing house there, and you can kind of see it from that picture, is built right up to the property line, and it's like you said, 5 to 6 feet. I think it's like 4.5 feet off the sidewalk. So the houses are basically going to go exactly where the existing house was.
Okay, that's helpful.
Joey, so what happens when one house is closer than the setback and a new house is constructed? Does that come into
it? It plays into our averaging.
Well, I meant if he builds like this and he's 2 feet away from the property line, and then the property changes, and right now the setback is 5 on the side, correct?
Yes.
For that new house, so they would only be 7 feet apart. But is there any consideration, like does that put any burden on the future? Are we setting any dominoes in place that push setbacks back? And maybe it's more of a fire code issue or window opening issue.
Well, there's not the zoning code. Let's just take a hypothetical that the house in the upper left photograph here in this photo, if that house is removed, somebody wants to come build a new one. So were you to grant this variance, Mr. Choate, we'd measure the next house down plus his divided by 2. If that number came out less than 20, he still got to set at 20. But there's not I'm
talking about the side setback.
Right.
I'm sorry.
I guess what you're envisioning is there's 5 feet typically between homes required from the home to the property line, therefore sort of averaging 10 between the two. There's really not. I mean, if you grant that variance, this next guy can build at 5 and you'd have 7 between it. But I'm not aware there would be a building or fire code issue with 7 feet.
And originally, with us looking at the lot, I mean, it's 64 by 100. We planned on building very similar to this on the property, and then all of a sudden, you find a sewer line in the middle of it, and there's no warning. I mean, there is no easement. I mean, you're blindsided by it, literally, and that is definitely a hardship. You go out and you buy something, it should be there, and Metro should have to warn people if Metro has a water or sewer line there. And then if they can just go in and say, no, you just can't build on it, and there's no compensation because you can't build on it, that is more than a hardship. I mean, that's a lot of money just being given to somebody, just being taken away from the homeowner and the landowner without a warning, without a hearing, without anything. My lot was cut from 64 feet to 51 feet by just talking to a neighbor.
Why don't you walk us through this? Because if I understand these two's complaint, it's could you just build, or not complaint, that's the wrong word, concerns. If you just built one house, you probably wouldn't be working working with 3 setback issues. So what are the economics of this? What did you buy the lot for, and what will you need to be able to sell these houses for to not be underwater?
If I can only build one house, I'll be underwater on the deal.
Okay.
Because I paid $55,000 with hopes to being able to build two.
Okay.
And ideally over there they want about 1,700 square foot houses. I mean, I'm a CPA. We did and that's what drives me even crazier is the fact that I am a CPA. We're paid to take care of the details.
Okay, and so as an alternative, instead of building one 1,700, what if you built one 2,800? I mean, is 28 going to fit in the neighborhood, or is it not? Are you going to be able to sell it? I mean, walk me through. I'm not familiar with it.
He did. He has a 20. How big is your house?
2850.
His house is 2850.
But it probably will be sold in a time, not now, because the price range it's not this small wagon looks houses, which are sold about 200, whatever. 30, 50, 60. The house by square.
I'm sorry, can I get you to come up to the table and introduce yourself? Thank you.
First of all, where is the button? Here. First of all, this sewer line, it's a pain, not only for your department, but for Metro codes. I figure out this line only because of Mr. King, who used to work over there, a good friend, and only on the old blueprints, it's a 6-foot sewer line, brick sewer line, which are nowhere existing. Not true? It's true. Yeah, I was inside. I know everything about this pipe. And I also was involved in some expenses because I should move my house. I should give them the easement and move my house a little, so I should move my property lines. I bought three lots over there. But when I saw Scott, I mentioned to him, but he already bought it. It's a problem. It should be somewhere. People should be warned somehow.
There needs to be a warning, because it could bankrupt somebody really, really quick.
No, I'm not debating. Did I understand you correctly to say you built a 2,850?
Yeah. Now about finances. Okay. I tried to sell my house about $140 per square feet, which makes my house to be about $400,000. The smaller houses, the kind which Scott, I don't know your last name. I said Scott.
It's all good.
It's fine.
If you would, for the record, would you state your name, please?
Closer? Yeah.
No, he wanted you to state your name for the record, please.
My name, yes. Felix Lubarsky. I came to United States 25 years ago from Ukraine, Russia. So I'm trying to sell my house for about $140 per square foot. Scott predicted that if he sells his house for about $68 per square foot, his head would be over the water. I don't know, but with my price, think about that, $142, it's lower than everybody else in this area. I have all the house with the hardwood floors, granite. I designed the house myself and I built it myself. Everything you mentioned is in the house. And I can sell it because it's not a ranch of this area. And I understand, to be able to survive, he should build two houses. That is his hardship. personally, I would be working with attached garages, but he can't. The sewer line, it's like a rope on his neck. But I would like very much him to demolish this house. It's like a...
Okay, but I'm just trying to make sure I'm understanding you correctly. You did build the size house we're talking about his having to build. You're trying to sell yours at under market. You're not being able to sell it even though it has the amenities, and so...
I didn't say under market. I said that's my price because I built it myself. And I did a lot of work myself, not only managing, or I'm a different builder. I do a lot of work myself with my hands. And I am able to be making my money even if I sell lower. We are not talking about me, we're talking about him. And he would not survive with $142.
Actually, I'm not trying to bring your house in for any other reason but to show his hardship is the only reason. Okay.
Yeah.
All right. So anyway.
No, I'm not
Thank
talking
you.
about myself.
Any other questions? Okay, then we're going to close the public hearing and have a discussion.
I have a question for Joy about the alley. If there's that much room between the drive, the paved part of the alley and the property lines, is it an extra wide alley, or is the alley is the drive on the other people's property?
No, the right-of-way for the alley varies between 12 to 15 feet. They just don't pave all of it. Some of that grass area, which you see in my photograph down here in the bottom right, is actual city right-of-way.
If you would have another, I'm sorry to interfere, but if you see another property, you will see that they built 4 units about the same size what Scott liked to build, and they are probably the size from the side at probably 2 feet or so. The alley, it's about, I would say, 12 foot, not more than that.
Thank you. All right, back to discussion.
Unfortunately, we cannot consider financial as a part of a hardship, so.
Well, as the only hardship, I think, is how it's worded. But I'm sort of inclined to, I don't know, I think the physical hardships, aside from the financial part, I think the physical hardships are somewhat self-imposed in that, the product is driving the hardship.
But I understood the testimony before us to say that, I hear where we're going, and to some extent it's kind of, are we self-imposing what, I think that I find not being able to find the sewer line there on a public record very compelling. And so I put that out first, that if you were to purchase that property, no matter what you put there, to learn later that the sewer line was there and the hardship had been imposed was compelling to me. But then, two, I understood the testimony to be that a house that size in that neighborhood is not really marketable. And I think based on personal knowledge, I would agree. That's a large size house that we're moving him to. Now, I understand you could say you could move something to that house, but you virtually have an empty, you would never sell a house. It'd be very difficult to sell that piece of property based on the testimony. So I take that into consideration. And I think that some of it's self-imposed because he'd like to put green space there, and I find that commendable and something, he could move the garage back in and reduce some of that, but green space is good. And the final thing I take into account is his neighbors want this. His neighbors want it greatly. So I think that those are all very compelling things to consider.
Yeah, I agree with that. And, when I first, without hearing the story, receiving the packet, a couple days ago and reviewing the cases, the questions I had were, what is the point of the 3-foot alley setback? And I think that was well explained. Were the paved alley at 3 feet, I probably would have a bigger problem with it. I do think it's different than the examples we were shown in terms of the garages, but I don't have an issue with that. I do think that what's going on in that neighborhood is this reflects that. I am concerned in general, not as much in this case, but in general with, and I don't mean this offensive to this proposal at all, but I'll say a lack of creativity for how to use your lot to get 2 houses out of it. But I do know that what in this specific case, and this is why I'm sympathetic also, is that it does look like what's going on in Salem Town. It does look like how the neighborhood is changing and evolving. It's not really pushing the envelope in terms of what the new construction is going on. It feels very much in fitting with what's going on. I worry a little bit about the 2-foot side setback. Not enough to say no, but I do worry a little bit about that.
But I think the 2-foot side setback, so let me get back into that. I think if you were to impose a duplex versus, I just think that the trend has been towards single-family residents that are not attached, and especially in that area. But then if I understand the 2-foot side setback, we're talking about we're asking the variance from the sewer line, correct?
Well, this would be on the opposite side.
Yeah.
But that person actually had, but when you're looking at the encroachment, and when you're looking at, first let me come back to the alley. I concur with you there. It's a difference when you do worry about safety and visibility and the impact on other people when you're not creating enough space. But you're correct that I agree with you that I think unlike the other pictures, this alley has a lot of space, but the 2-foot side setback, or I guess we're talking about on the left side based on what we were looking at, that person actually has, I thought we said 17 feet total. I mean, I know it's from the property line, but you're actually separated by 17 feet from the house itself.
Yeah, and I was just thinking about, and again, it's not just thinking about how does that put any burdens on the property rights of that person should someone buy that lot and want to do the exact same type of building. I don't think it does. I think that I doubt there's a 6-foot sewer going through that property if there's one going through this one. I think that you could probably come off 5 feet on that one, do the same type of building if that's, again, it's speculative. So. And
I think, you always want to be careful that you're not setting precedent or granting, that these really are the exception rather than the rule. But the difference here is the sewer line, and the surprise to any homeowner who purchases property that has a structure on it that needs to be demolished, that you find, to your surprise, a sewer line that you couldn't find under reasonable due diligence. And I think that separates this case and makes it unique from others.
I agree with there absolutely was evidence that a lot of work was done to see if this was acceptable, and it came very, very late and unexpectedly. And so I wouldn't be as sympathetic to folks that didn't go through that process.
Are we asking for 3 variances here, front, side, and rear? I mean, that's a bit much for me, three variances here. Why? I can understand a side yard and a sewer line.
But because what you're asking, I don't think that there's magic in the numbers on how many variances you're asking. I think if you look at the property in its totality and the unique features of that lot, if you didn't grant the front variance, then you would be decreasing. What he's attempting to do is grant some measure of green space and to put a backyard there that would be consistent with the look and feel of the neighborhood. That would be things that the neighborhood values. And what you'd be doing is taking away green space. And I think it's consistent with the other property, but I still say it's all necessitated by the sewer line that's running through the property. And I'm not sure that if it were 2, I'm not sure that it matters if it was 1, 2, or 3, or 5, or 10. The unique shape, the unique characteristics of this parcel of land necessitate that all these three things have to happen. And it's unusual, but
The front variance, they're just asking to build a house where it is, right? Isn't that the case? I mean, that the current house exists where the front variance, and I think the variance changes because the house is torn down, and then it's averaged between the two next to it, which is what
But the new
pushes it
house is
back.
a lot taller, and there's a lot more frontage to the proposed structure than what's there now. I mean, I think that's significant. And I don't necessarily think that it's the number of variances that he's asking for, but it's really not that's not the problem in of itself, but I think it is a symptom of sort of the larger problems that I'm grappling with. The property itself, with the exception of the corner lot, looks to be the largest property on the block. And, even when you take away the 13 feet or whatever, if all the lots were the same and then you had this magic easement show through it, then I think, you're seriously restricting it. But, and not to be harsh in talking about due diligence, I mean, if this is an investment property, I think I would have spent $400 or $500 on a survey, and the drawings are wrong from Metro, but a competent surveyor would have seen that I think there was a drawing that had the manhole cover, showed where the manholes were, and you connect the dots between the manholes and you have a sewer line, generally speaking. So that that would have raised a red flag right there that hey, these manhole covers aren't anywhere near where they say they are on the map, and why is that? That would have been the first flag for me.
But I think the testimony was that he did hire a surveyor, correct?
I don't think he did say there was a surveyor.
I thought he had, but
what we have, which I think is going to be a really harsh result if we go there, is we've got government regulations driving the owner for whatever reason to build a product that's not in keeping with the neighborhood and is going to be harder to sell. And it all kind of results from a defect in the property, which also stems from the government and is nowhere recorded. That's a really harsh result.
But I don't think it would have caused the front setback or the rear setback problem.
Well, no. I mean, I think we're saying you can build a 2,850 square foot house, but that's just not in keeping with the neighborhood and not what the neighbors want.
Okay, well, take it from this direction. If he could have built what he's proposing without the variances to start with when he bought the property, this works. Oh, by the way, you have this unknown sewer easement. Then I'm like, that's compelling to me. But when it starts to collect these other variances, that to me is the signal that, and that's where I get the front and the back issue.
Yeah, I don't have the front and back issue. I don't have an issue with the front and the back. The front is, say, build the house exactly, in line with where it was, and the back only because, you've got another 7 feet. I mean, if it were 3 feet off the paved alley, I would have a real problem with it. But, it was clearly shown that there's this right-of-way that I guess the neighbors, everybody uses, but it's really not your property, and you do get that kind of 10 feet off the alley. I think it's, to me, those two are fine. I think that the one I had a problem with was the side setback, and I think that's completely dictated by the sewer, and I'm sympathetic with, I'm sympathetic with that.
I am too, but I almost feel like we're saying, let's throw away the zoning and what the planning has done. We have a property, we have a developer that sees a need and a use, and he can do that, and let's just throw away the zoning book, and I see our role is a little bit different from that. And I agree, it's probably a workable product, a very nice product, but I don't think that's my role here.
But variances are part of the code as well. I mean, that's why we exist. I mean, we are the variance people, and see, it's as much a part of the code as anything else. I mean, and to me, I guess as a guy that used to kind of draft these, the council puts these cookie cutter things, where we need a 5-foot setback, and then they apply it to thousands of pieces of property, whether it's the right thing or not. I mean, and that's not a criticism of the council. It's just they're hitting with a big sledgehammer, and then we're brought in to figure out the little ones. And so, anyway, I get it. I'm not questioning it. It's just I do see a hardship, and I think this is a pretty good opportunity for a variance. But
do you want to put forth a motion, or I will?
I'm going to let you.
All right. I think that you stated very well the reasons that this variance should be granted. But I will move to grant the request for this variance for all three variances. Can I do them together, or do I need to have them set? For all three variances, based on exceptional characteristics of the property, including the sewer line and the public easement in the rear, and I'll leave it there.
I'll second.
All in favor? Aye. Let's use hands, probably.
Under our rules, we have a tie vote. This case will stay on our agenda for the next 30 days. The one member eligible to participate, Ms. Jones, is able to, if she reviews the record. The 5 members present are also allowed at the next meeting to change their vote. We'll call this up at the beginning of the hearing. First ask, do any of the members wish to change their votes? I'll recap the vote total. Then ask Ms. Jones if she's present, has she reviewed the record, and would she like to participate? With that, after 30 days, if no votes are changed, stays as is, this case will be deemed denied. With that, the Board of Zoning Appeals is adjourned for today. Thank you.
Thanks.
Thank you.